Hello and welcome. I'm Carolyn Grimminger with the Public Affairs Forum of the First Unitarian Universalist Church of Austin. Our program's mission is to nourish the mind and spirit and serve social justice. Our forums occur on most Sundays at noon and are free and open to the public. We encourage you to attend. Our church is located at 4700 Grover Avenue. For more information about our Public Affairs Forum, you can go to our church website at www.austinuu.org. And now Eric Hartman will introduce today's speaker, Mr. Jack Getman.
I'm happy to be here to introduce our speaker today for our annual Labor Day weekend Public Affairs Forum. We call this the Kitty Clark Memorial Forum in honor of a great member of this congregation and a great member of the leader of the Texas labor movement, who was an inspiration to many of us over many decades of activism here in Austin and across the state. I know she would be really pleased to be here for today's talk, to hear one of the nation's leading scholars of labor law. Our speaker today is retired University of Texas Law School professor Jack Getman, who is, I'd like to say, so much more than a labor law expert. We're talking here about a man who is a great teacher. He exemplifies to me what C. Wright Mills once referred to as the sociological imagination, reaching beyond the confines of any one particular discipline to make connections and see things that we wouldn't otherwise see. He's as Mills also said, he's someone who helps you understand that what may seem like individual troubles really have much to do with social problems and political power relationships. He has just published a new book on the role of the U.S. Supreme Court in weakening the U.S. labor movement. His contention, which you'll hear more about, is that the confrontation over many years with hostile judges has promoted anti-union doctrines that have played a central part in the weakening of the U.S. labor movement. His book, which I just happen to have a copy of here to display, The Supreme Court on Unions Why Labor Law is Failing American Workers, could scarcely be more timely. We are at a point right now with the U.S. Supreme Court evenly divided in a number of key cases on labor issues. And the next justice, whoever that is as a result of the political process that still has to unfold, could be a deciding vote and could lead us to a turning point on this crucial area of law. I'd like to, just by way of one further point, mention what one of Professor Getman's students, who's gone on to bigger and better things, has said of him recently. He said, "He has a remarkable blend of realism, sardonic humor, and perceptive insights analytically about the real world." Quite a testimonial. Please join me in welcoming Professor Jack Getman.
Thanks. I'm going to try to speak briefly because I always find that the best part of any presentation is question and answer. So I'll tell you briefly about the book, and then I hope we can have some kind of a dialogue. The book that I wrote, The Supreme Court on Unions, Why Labor Law is Failing American Workers, I'm critical of the court for two reasons. One of which is obvious. There's a strong anti-union bias in many of the judges. Thus, for example, Justice Thomas could say that the union had adequate opportunity to make its case to the workers as to unionization if it could put up a sign along the highway while the employer was having regular, what are known as captive audience speeches. Well, that's so absurd that you realize that there's an anti-union bias at work. With Justice Scalia recently passed, it was very important. He saw unions as a distortion of the market, and he believed in the market. And of course, unions are a distortion of the market. If they're doing any good at all, they're distorting the market by substituting collective bargaining for individual bargaining. Justice Scalia thought that individual bargaining would create the proper conditions for the economy. So his bias was an intellectual bias. It's hard to tell where Justice Thomas's bias has come from, but there's a lot of bias. But in addition to that, there's a lot of ignorance. Even the pro-union opinions by the court are often reveal that they don't understand very much about labor, don't know what working people, what issues they confront. And so you could get, for example, Justice Douglas, great liberal justice, describing labor arbitration in words that no labor arbitrator, and I did it for many years as a labor arbitrator, somebody said he had many arbitrators looking in the mirror. Who was this person? You know, it's like the old joke about the wake where the wife says, go look and see if it's your father they're talking about. Well, as an arbitrator, I said, who is that the Supreme Court is talking about? It certainly isn't me, and it isn't the other arbitrators. So you have a combination of bias and ignorance. And the court has been the major decider of public policy issues on labor since 1949. So we have 60 years where Congress has done nothing and the court has been the major voice on public policy on labor. During that time, they have taken labor law and turned it completely around. The law still on the books says that it is the policy of the United States to promote the practice of collective bargaining. And the idea was to promote collective bargaining as an alternative to individual bargaining on the theory that working people needed to bargain collectively to be able to in any small way, bargain effectively with their employers. Now, in order to have collective bargaining, as in fact the dominant method of setting wages, hours, and conditions of employment, you need a strong labor movement, which means, and the strength of the labor movement is determined by a variety of legally, the ability to organize, the ability to actually bargain, and the ability to bargain actually depends on your right to strike. And add a fourth thing for the law is the ability to have injustices corrected. Now, the Supreme Court has managed to change the law in every one of these directions. The first thing they did, and I think the most significant, was by gutting the right to strike. The National Labor Relations Act in two places specifies that there is a right to strike, and it says any employer interference with the basic rights, including the right to strike, is an unfair labor practice. That was barely on the books when the Supreme Court announced that an employer has a right to permanently replace strikers. I mean, permanently replace them. You go on strike, you lose your job. A book I wrote about a strike by paper workers in the town of Jay, Maine, 1,200 paper workers, all of whom were permanently replaced. The devastation just was enormous in this entire community. They had a right to strike, but you wouldn't know it from the closed up stores and the homes for sale and the lives ruined. It was a tragedy of major proportions. I was thinking back in the day when I used to teach the steel workers unions in Indiana, I would tell them, well, you have a right to strike, but you can be permanently replaced. It took a long time for them to believe me. I would get questions, no, you said we have a right to strike, right? I'd say, yes, you have a right to strike, but we can lose our jobs permanently, you're saying. Yes, you can lose your jobs permanently. Well, how can we lose our jobs permanently if we have a right to strike? And I would say, well, because the law is stupid, or some equivalent to that. Then they would say, and this is for many, how come when we strike, we don't get permanently replaced? And I would say that's because you have a damn strong union, and nobody wants to take on the steel. Because if you have a strike at Diamond Chain and they replace everybody at Diamond Chain, there's a battle that will go on for decades with the union in a whole variety of ways, and they don't want to do that. They don't want to take on the steel workers because you're too powerful. So for many years, the labor movement was able to strike effectively because they were powerful. But because of the declining membership and because employers learned that they could turn the ability to hire permanent replacements into a very powerful weapon against unions. The strike at J. Main, for example, was typical of a whole bunch of strikes in the 1980s where employers permanently replaced the strikers. Then the scabs, as they were affectionately known, would vote the union out. And so you got rid of the union, and you had a basically servile, grateful workforce. And employers started doing it more and more. During all this time, it is perfectly clear, and writing the legal brief against striker replacement would be fairly simple for a first-year law student, or at least a law student who'd taken basic labor law. But the Supreme Court is reaffirming it over and over and over again. There's one case where the court dealt with the right of an employer to hire, to give. The Supreme Court said, no, you can't do that. It interferes with the right to strike. Everything the court said applied to the hiring of permanent replacements. But they said, we don't mean here to question the doctrine about replacements, which is known as the McKay Doctrine. So the court has over and over and over again reaffirmed this crazy rule that despite the right to strike, you can lose your job. Now, why are unions weak? Well, for one thing, it's enormously difficult to organize. Now, I should say, I guess in order to be truthful, unions have not done a very good job of organizing. And I wrote another book about that called Restoring the Power of Unions. So they bear, and I'd be certainly willing to explain why, but they bear some of the responsibility for not organizing effectively. But the Supreme Court has given employers a major advantage. In order for a union under the law to become a bargaining representative of a group of workers, it has to win an election in which the employees either vote yes or no for the union. And that's why many of you will remember they had the Union Yes campaign, vote yes for unions. So, and before the vote, there is something like a political campaign. The Supreme Court has set the terms of the campaign. And it's as follows. Employers have the right to call all of the employees together as often as they want and to make the case against unionization. This is why, and they always say the same thing. And by the way, one of the main things employers will say in order to defeat unions is if you vote to unionize, I will bargain with the union, but I will bargain tough. And the only way the union can get anything for you is to, they'll often say, drag you out or pull you out on strike. And if you're out on strike, you can be permanently replaced. That's a powerful argument. That is a powerful argument that many employees don't know. The union now, if we were going to have a reasonable rules about campaigning, first of all, you'd limit how often employers could do it, but secondly, you would give the union some right to reply. You say, if you're going to hold captive audience speeches, they had this in California, you have to give the union a chance to respond under equal circumstances. No, the Supreme Court, in the opinion that I mentioned by Justice Thomas, said it was the labor board could not give unions the right to enter onto the parking lot in response to the employer's speeches. They couldn't have a union. The labor board said, well, in order to try to equalize things, we will permit the union to meet in the parking lot during time when employees are coming and leaving work. And Justice Thomas, speaking for the majority of the court, said, no, that's not fair. The employer, it's the employer's property. He has a right to decide who comes on it and who can't come on it. And he said that the union, under previous doctrine, it was the union had to have a reasonable response. He said they could put signs up along the highway to notify people that there was a union campaign going on, which you could then include the union's phone number and you'd call it up. Now, I did a study of union organizing for 12 years in which I interviewed workers, interviewed union organizers, interviewed management representatives. So I know something about the dynamic of a union organizing campaign, and we did an index, how well people knew the union's arguments and how well they knew the employers. Well, overwhelmingly, they knew the employers' arguments way better than they knew the union's arguments. That was because they'd gone to meetings. They had not gone to union meetings. And by the way, it wasn't that they weren't interested, but to get out to the union hall after work, they mostly said they were too busy, they didn't have the time, all of that. So the employers have a massive advantage in getting their arguments heard by the workers. And you imagine if you had a political campaign where, one of the candidates gets all the airtime and the other one has to travel around the borders of the state or of the country to get their message heard. Of course you wouldn't have a fair election. So the Supreme Court has massively disadvantaged unions when it comes to organizing. They've massively disadvantaged them as to collective bargaining when it comes to striking. And in bargaining, the court, through a series of absurd opinions, has given employers the right to make major decisions without bargaining with the union. And they've done that, I say, this is where the combination of ignorance and bias comes into play. For example, they've set up a division between topics which the employer has to bargain about and other topics where the employer doesn't have to bargain. And this is called the mandatory permissive distinction, which I won't bother setting out. But the court announced that in bargaining, if you were to bargain about a permissive topic, it would somehow be a refusal to bargain about mandatory topics. Since I have an advantage over the court because I have experience in this field. I was the chief bargaining representative for 6 years for the Connecticut State Police. In truth, when you want to bargain for a permissive subject, you want to bargain more for the mandatory topic because you've got to give the other side something in order to get them to accept the permissive topic. So the idea that by insisting on a permissive topic, and permissive topics are the important one. The court has said, for example, that whether the employer is going to close down is a permissive topic. So for the union to be able to bargain about that, is very important for them. And in truth, if they could get a provision limiting the employer's ability to close down, they'd give up something on wages or something else. So the court's comment is totally backwards. I'll just mention one other recent area where the court has made matters even more difficult for unions, and that's in the area of arbitration, which is really very, very interesting if one traces out its history. The Supreme Court, for a long time, an interesting fact about labor relations in the United States, when unions were strong, after World War II, into the 60s and 70s, every collective agreement would have a provision that stated that if there's any dispute as to the meaning of this agreement, the union may file a grievance and you could go to successive meetings about trying to resolve it, and if you couldn't resolve it, you could go to arbitration. And the arbitrators, and as I say, I was an arbitrator for about 20 years, the arbitrators were chosen by the parties. And in order to be an arbitrator, because you were chosen by both labor and management, you had to have a reputation, at least for being fairly neutral, and so on. I eventually lost that reputation, or actually gave it up willingly. But the fact is, you needed that, and it was a system that worked pretty well. And it worked for many years before anybody knew whether the promise to arbitrate was legally binding or not. It came before the Supreme Court. The Supreme Court said, yes, it is. It's a great system, and it is binding on employers to arbitrate, and then stated that the arbitrators are chosen because they have deep insight into productivity and all sorts, and knew the law of the shop. And everything the court said about the process, as I said, was totally different from not only my experience, from that of most other arbitrators. So the court overpraised arbitration and overstated what arbitrators were capable of doing. So there was a general, and this was Justice Douglas, a general statement that arbitrators are very competent to deal with all kinds of issues, which in fact we weren't competent to deal with. And being an arbitrator has real limitations, even as to fact-finding, for lots of reasons. So then the court expanded they make the doctrine that the promise to arbitrate is binding. And somewhere in the opinion, Justice says, the promise to arbitrate is the quid pro quo of the no strike clause by the union. So it means, as the court viewed collective bargaining, the union would ask for an arbitration clause, and the employer would say, we'll give it to you we'll give you an arbitration clause if you sign a no strike clause. And the union would say, all right, we'll sign the no strike clause. And that's how the court interpreted what was going on in collective bargaining. Now they get a case from the Teamsters Union, which back in those days was a very powerful union. And the Teamsters wanted arbitration, but of course they did not want a no strike clause. So in comes a contract, doesn't have a right to strike clause, a no strike clause, but it has a broad arbitration clause. The Supreme Court says, well, since the one is the quid pro quo for the other, they must have intended. I mean, this is unbelievably simplistic. They must have intended, but somehow they didn't get around to writing the no strike clause. So the Supreme Court writes in a no strike clause, despite the fact that there's not one in the contract by the parties after collective bargaining. Because, you know, in the days when the Teamsters were very strong in dealing with small employers, they said, here's the contract, sign it. And it wasn't a mistake that there wasn't a no strike clause. The court just read it in. Then they decided that under what's known as the Federal Arbitration Act, arbitrators have the ability to deal with all kinds of questions of law, which, by the way, the National Academy of Arbitrators, of which I was then a member, which was the group that kind of represented leading arbitrators, said, we're really not good at deciding issues of law. So you had the arbitrators saying, we're not really good, and the arbitrators were right. It's not an unusually modest group. So when they said, turn that around. They said, no, arbitrators can handle questions of law. It's not a problem. That led to a decision. Oh, am I not being? Okay, sorry. So that led to an opinion by Justice Scalia, which basically said employers can, and they are overwhelmingly doing this, put into the contracts of employment or contracts of sale, they can put in a clause that says if there's any legal dispute, afterwards, it will be settled through arbitration, and it will be done on an individual basis. Now, for employees, for example, whose, let us say that the salary structure under the Fair Labor Standards Act, well, let's say it requires break time and overtime beyond 8 hours. Now, let us say a worker who's earning, $10, $20 an hour, let's say, isn't being paid adequately, is forced to work overtime. In order to protest this, said the Supreme Court, you have to go to arbitration in accordance with the terms of your contract. And employers always put in, you have to do it on your own. Well, a worker cannot do arbitration on their own. They have to go out and get a lawyer. But imagine this case of a worker earning $10 or $20 an hour. They're not going to be able to get a lawyer. They couldn't afford a lawyer. So it's meaningless. Plus, the companies can essentially now pick the arbitrators, or pick arbitrators who have promised to protect the company's interests, who aren't at all neutral. The one thing about the old system on the collective bargaining was that the arbitrators were neutral. Currently, the arbitrators are almost advertising, I'm pro-management, and the court has affirmed over and over their ability to do this. So that's a current issue which will be decided by the next Supreme Court. So as I think I've tried to demonstrate quickly, you have the right to strike being sabotaged, the right to organize being defeated, the right to bargain collectively being minimized. All this by the Supreme Court, as I say, displaying a combination of ignorance and bias, which has served to deprive workers of their basic rights under the law. The conclusion of my book is that even if you have a Democratic president, it's going to be very difficult to turn the court around adequately. And even liberal courts were not great on labor, which raises another issue. Particularly, is one of my pet peeves, that the labor movement has less political clout than they did previously, and in my opinion should have, so that you'd have to worry about whether we'd get people who actually knew something about labor on the court. Okay.
We have a question from Glenn Williams.
Yes, my question is about Texas public employee unions. If you were asked to advise them, what would you tell them to do?
You know, that's a terrific question, and it's really what sort of my previous book was about, how unions can become powerful, regardless of the law. And it's not an easy business at all. It's very, very difficult. But the main thing to recognize, and I almost hate to be this preachy, but I think it's very important, is that you have to use the members and get the members involved. You cannot have an effective union where the people who are active are the leaders of the union, a small handful, And you can't, you really need a democratic, active union. And the business, the temptation on the part of union leaders and professionals to exclude the members is very great. It's a quick anecdote. When I was bargaining for the state police union, public employee union in Connecticut, the members would come, we had a rule, and all the members could come to the negotiations, and they actually did not understand what was going on, and they would constantly come up with ideas which were totally worthless, but which we had to deal with. It made bargaining much more difficult. If we could have just bargained with the employer, we would have finished earlier, but we had the members. So the members can be, to put it not politely, a real pain in the ass when you're bargaining. And and in any union activity, member activity gets in the way of efficient operation, but it's absolutely crucial. I'll give you an example for that same negotiation. As I say, it took the members a long time. Then they suddenly realized that we had a pretty good contract proposal which the state wasn't accepting. What the state police did on July 4th of that year, they stopped issuing tickets. They stopped people. They were out on the road saying, "Excuse me, sir, excuse me, madam, you're traveling too quickly. Would you slow down?" But because of the impasse in negotiation, we're not going to give you a ticket. Of course, people thought that was great. They were minding, and they were getting, and within 2 days of this, I got a call. We've got to settle this. We met and we settled it. So it was the members, pained though they were, it was the members who got the contract. And the members have to, at Yale, when the clerical workers at Yale struck and they were risking their jobs, as every union does, they were the ones who won the strike. It's always the members, and the union is always more effective if it uses the members and involves the members. Now, we just came, my wife and I were at a Labor Day picnic in Houston. And I was actually really very unhappy with it. Why? Because it was one politician after another saying, "Hey, if you vote for me, I'm going to be for." There was you never heard the workers' voice. The clerical union, which organized Yale and was a model, best union organizing job I've ever seen, it was always the workers' voice you heard. There was a woman named Lucille Dickus who had been a clerical worker who became the president of the union. She was a great speaker. But it doesn't even matter. Anytime you see union activity, if you hear the member's voice, it's more effective than if you hear the leader's voice. But a lot of leaders find that very uncomfortable. They want to do the speaking. They want to represent the union.
Yeah, I'm a follower of Noam Chomsky, and I've been listening to some of his recent presentations. And my perception is that New Deal of FDR was basically a thorn on the side of the employers. And so since its passage, the employers have been trying to get rid of it. And slowly, through political action.
Which legislation are we talking about?
I'm talking about the New Deal.
The New Deal?
Right.
Okay, we're back to that battle.
Because the thing was, that was the legislation which averted a pretty big crisis in the nation. So that became a thorn, and they wanted to get rid of it. And slowly, they each administration tried to take teeth out of the legislation.
Yeah, I don't believe that. I believe because during the New Deal and the passage of the original Wagner Act, the membership in unions went from 2 million to 12 million, then on to 20 million. So the unions were able to organize, and they bargained successfully, not only for their own members, but for all workers in the United States, because even the non-union employers were watching what the unions got. And so workers in general in the United States were satisfied with their working conditions. I was in Indiana. I remember Cumming Engines, which is the biggest manufacturer in central Indiana. Their lawyer told me he watches exactly what the UAW gets, and he gives it to his workers. So the unions were very, very powerful and very, very effective, not only during the early days of the New Deal, but afterwards. Now, there is a question of why did unions become weak? In my opinion, it's because they became too run by their leaders, not democratic. There was a real disconnect between the leadership of the unions and the membership. And I think that's much more than this kind of fancy political science of Noam Chomsky. I know he's very smart, but I don't agree with that. But I gave a Washington radio station. I did an interview on this book, and then there was a whole bunch of call-ins, and every one of the call-ins was from a worker who was dissatisfied with their union. And that's a real honest-to-God problem. As I mentioned, the most democratic organizing drive I witnessed was the clerical and technical workers at Yale. 20 years, now 30 years after that, they are the most dominant political force in New Haven, that union, and they are a major voice in the Democratic Party. And they've done it because they've remained a members' union. And I went when I gave a talk on my book there, and it was inspiring. It was inspiring. The union leader didn't speak. First thing they did, all the people who'd been taking part in the 1984 strike came out, everybody cheered. Then the graduate students came out who had a very different claim, but there was this sense of solidarity that you could have practically put it on bread and eat it as a sandwich. And when you see union solidarity in action, it's very inspiring.
Thank you. I really appreciate your presentation today, sir. As a lawyer, I'm learning a lot from it. I have a question that goes toward the future, if you will. There's great concern now that our economy is changing, less and less income coming to people. As a consequence, long term, the broad population probably won't have the money to pay for a lot of the things that management and business is selling. That's an issue wrapped up with another one that's specifically an issue of labor. We're going to have a seminar here on a book coming here in a few weeks, Rise of Robotics, Technology, and the Threat of a Jobless Future. The way business is changing now, whether it be industrial, manufacturing business where jobs have been taken over by robotics, or even professions like lawyers where computers have taken over preparation of a lot of things like discovery. We're getting to the point that there may not be any need for human labor in a great deal of business. What does that mean?
God, I don't know, but it's going to be a while before it happens. And there are a lot of people who are going to do a lot of hard work between now and then. And I would point out that there seems to be a slow but steady increase in manufacturing jobs. There are all these service jobs. There are hotel jobs and restaurant jobs. One of the most important things for the future of organized labor, for example, is the Fight for 15 and the effort by the Service Employees International Union to organize the fast food workers and the effort by the hotel unions to organize the service workers, for example, in San Antonio. And those campaigns, both campaigns, are actually being well run. They're both campaigns in which the workers' voice predominates. They're democratically run unions, and they're making progress. You know, cities after city are enacting this $15 an hour minimum. The the causes become politically popular. It helped to fuel Bernie Sanders' campaign. My point is, there's still a lot of life and a lot of potential for labor.
We have a question from Eric Hartman.
Since I haven't had the pleasure of reading the book yet, I'll ask a question about one topic in it. You talked about obstacles to the showing of solidarity within labor in conflict with management. And I think one of the issues here is the issue of the use of boycotts, secondary boycotts, and restrictions on that. I wonder if you could speak to that.
Oh, thank you. Great question and point. And I should have actually spoken to it earlier. And one of the legal issues that's involved is the extent to which picketing by unions can be regulated under the law. The Taft-Hartley law, the major change in the original Wagner Act, the big change was outlawing secondary boycotts. And secondary boycotts really take place in two ways. One, when a union pickets at a store and asks people not to purchase anything, or not to patronize. And secondly, when unions ask other workers who are connected to the employer they're striking to support them, let's say not making pickups, not making deliveries, not working on parts. Now the law, as it has been interpreted, prohibits union picketing in a variety of situations from seeking the help either of the general public or of the or of other workers. So unions, crazily enough, unions have the right to ask the employers to help them. But if they ask consumers or other workers, it's illegal. It's another crazy aspect of the law. The Supreme Court has recently reaffirmed something it first decided in a labor case, which was that picketing is a form of free speech. If picketing is a form of free speech, then all the prohibitions on secondary boycotts can be wiped out. It would be wiped out, in fact. The court has not ruled recently on whether the unions have the same free speech right that, say, the Westboro Baptist Church has to picket with signs saying God hates fags, which the court was very proud of their commitment to free speech and said this is picketing, but it's issues of real importance. Well, so are strikes issues of real importance. The court decided that many years ago. But still, the existing precedent is that strikes by unions or picketing by unions is regulatable under the Constitution and is not protected by the First Amendment. It's another example of something that makes no sense, and it would be a real major advantage to unions if the court were to hold that union picketing is as protected as picketing by every other group that the court has proudly said, well, they're picketing, including there's an opinion in a case involving the NAACP. And the court said, yes, it's picketing for equality, to end segregation. That stands on the highest rung of the First Amendment, which, needless to say, I applaud, or maybe not needless to say, but great. Then they went on to distinguish union picketing. They said, well, union picketing's not that important. It doesn't stand on the same high rung, which, when you think about it, makes no sense again. Because in each case, when the NAACP was boycotting, and they were boycotting for jobs, they were saying the economy is tilted against black people. And the court said, right, that's free speech in action. Unions said the economy is tilted against working people, and the court says, no, that's not that important. That's the current precedent. I'm not making this up, right? You think, well, this can't be right. Getman is exaggerating the stupidity of the court. But I wrote an article at the time saying you could only explain the difference between the treatment of the NAACP and the treatment of the unions by focusing on the immediate issue in the union case. That is, it's an economic issue. We want more money, we want better wages, and the long-term effort of the NAACP, which was equality. But the long-range plan of the union is, right, and at least in my opinion, similarly a majestic goal of improving the rights of working people in the United States. The court never mentioned that. It's like union picketing is about small-time economics. NAACP picketing is about the right to equality. Why the one and not the other? The union movement has been slow. I have urged former students of mine who are high up in the union hierarchy to raise this issue, and I have noticed a recent case by the Hotel and Restaurant Union where they have raised the constitutional issue on picketing. And probably they'll hold it back till we get another Supreme Court justice. But I think it's a potential win for organized labor.
We have a question from Douglas Bauer.
Thank you for a very interesting presentation. I wanted to comment about the post-World War II period. From the end of World War II to about 1980, as companies' earnings increased, the percentage of income that went to working people tracked pretty much with the company's gross earnings. Now, 1980 it decoupled, and it's been pretty much flat since then. Now, you could say, outsourcing or automation or whatever, but I wanted you to comment on the attacks on unions that occurred during that time.
Well, if you look at the date, probably the strong point for unions in the United States was the mid-'70s, and they've been going down since. From the '80s on, the decline has been notable. The decline of unions has had an enormous economic effect, and by the way, I believe it's also had a very strong political effect. Workers whose wages have gone down, who've seen the massive bonuses for top management and looked at their own stagnant wages, and they have nobody to turn to. They have nobody to turn to. And you can understand the anger. The anger of the people who are backing Donald Trump. And it is actually a curious political fact that I'll throw in on my own, that the Trump people, when asked who their second choices, were overwhelmingly Bernie, which demonstrates that there's a sense of a kind of working class anger which is justifiable and understandable, and which the Supreme Court helped to fuel. Not only the Supreme Court and the Democratic Party have both, there was a time when the Democrats were when the unions were part of any significant liberal coalition. And unions partly to blame, the law's partly to blame, the Supreme Court's partly to blame, but the country is the weaker for it. I believe for the country to thrive, for any country to thrive, you need a democratic, militant, progressive labor movement, and we don't have one.
We have a question from John Lindquist.
Thank you for being here. I have a couple of comments and then a question. I think that the Democratic Party is going to suffer greatly for passing over on Bernie and giving us Hillary instead. I think that it's a major mistake. I also would like to comment about the unions in America. They are alive and well. We just put the wrong name on them. The AMA is a union. The Nurses Association is a union. The Police Federation is a union. The Firemen's Organization is a union. The United States Senate of 100 men who vote their own paychecks is a union. My question for you now, sir, is out of Spain has come a group that is building new industries within their own communities where they are owned by, they are cooperatives where they are owned by the membership and where the members own the company, and we no longer depend on a capitalist to give us a paycheck. I wonder what your feelings are on that, if you know anything about it.
Well, I know very little, but what I do know is that efforts have been constantly made, and that issue has arisen many, many times over the years, but it's very, very difficult to translate that into reality. And it is true that if you say any group, any organized group that's supporting its own members as a union, then it's true that all these other groups are. But the ones that I'm concerned with are the unions that represent working people who don't really have a voice otherwise. The kind of unions that my father was a member of in the 1930s that taught him to read and gave him a decent salary. So I'm a union brat, but a working class union. I'm not talking, yes, I have very little, either the ABA or the AMA, yes, they have a lot of the attributes of unions. They're very successful. They make the rich and the powerful richer and more powerful. They don't need my help, I feel, or anybody else's help. I need the unions that represent workers, the people who represent the McDonald's workers at McDonald's or Wendy's. These are the unions that I'm concerned with, and the law singles them out to limit their traditional activities. So they're the ones, I think, that need the help of progressive people. Oh, yes, yes, they're not adequately, but...
We have about 5 minutes left, and a question from Luther Elmore.
Yes, just a moment ago you addressed the fall of the influence of labor in the 1980s, and you did not mention President Ronald Reagan. And so my question is, what, if any, impact did his, although it only affected a little over 10,000 employees, what, if any, effect did his impact of breaking PATCO, the Air Traffic Controllers Union, what effect did that have?
It's very hard to tell. To be fair, that is the common view among pro-union commentators, that the business of using the strike as a management weapon and getting rid of the workers began with PATCO. I don't quite accept that for the reason that the PATCO strike was unlawful, and the destruction of organized labor was done through strikes that were totally lawful. I mean, Reagan had a point. You had these people under the law, they weren't allowed to strike, and he replaced them. And I think the companies, in the following years, a lot of major companies forced unions to strike through tactics involved in the bargaining process, and then replaced them in order to get rid of the union. That's what the International Paper Company did in the people of J. Main. It was a different kind of dynamic, I think, than Reagan and PATCO. But nobody knows. The PATCO explanation is a fairly common one among people who think about this issue. I'm just something of an outlier on that.
We have another question from Douglas, from Bonnie Gardner.
Thank you for a great talk. And it seems like there are a lot of complicated distinctions about free speech, the content of speech, where you can exercise speech, and almost mind-boggling. What direction are we moving in terms of definitions of free speech, and in terms of our current Supreme Court? If you could talk a little bit, if you can speculate, on the personalities or philosophies of various justices, where they might fall on some of these issues if we get some cases relevant to that.
Okay, well, one of the things that's curious is you're not surprised to know that Ruth Ginsburg and Elena Kagan and Sonia Sotomayor and Breyer, more or less, are all advocates of free speech. Peculiarly, Roberts has made that very much a part of his intellectual stance, is for expanding free speech. So far, they have done it. For example, they've been very concerned. The court has been terrifically concerned with the rights of dissidents within unions. The conservatives in the court saying that somehow the free speech rights of workers who gain benefits from unions are violated by requiring them to pay a small part of the benefits that they get from the union. So the court has been pushing free speech, but pushing it in funny areas, like the Westboro Baptist Church, which, if the Westboro Baptist Church didn't really have the right to picket veterans' funerals, I would not mind. But if they're still holding, unions are not allowed to tell you, don't purchase here. They're selling or products made by scabs. I feel they ought to be able to do it. I think this court, I have a sense, and that's why I've been urging organized labor to raise this. I think they have a good chance of winning. Right now, of course, they're figuring if Hillary wins, we're likely to get another pro-free speech for labor voice, and so they're probably holding back on it. But I actually think that this is an issue that could be won even under the Roberts Court as currently constituted. But certainly nobody has accused this current labor movement, I think, of being too rash. They have been very careful, very political, and I think unfairly, improperly so.
Thank you for coming out today and speaking with us. Can we give Mr. Getman a hand?